Yes, please.
Daily list for orders item 1.
May you please, your lordship. My lord, with due respect, I am before your lordship because my earlier counsel who placed this fact, maybe it was a fault on our part that the provision of law was not been able to place before lordship. That as regards when an indigenous person has been allotted a land for a particular purpose, he within 3 years he is unable to do the particular purpose for which it was allotted, the term stands cancelled. And the PIL, the ground was that he has sold within 3 years the land which was allotted to him with third party, for which the PIL was filed. And the provision of law is in the, my lord, land policy. It is 4.1 in 1989, and the new policy of 2019 says that up to 15 years you cannot sell to somebody else. And my learned friend, maybe my lord ignorant on our part, was unable to place the law. That is why I am before your lordship with the review application. This is the particular provision of law.
Yes, what the law or you want? Tell us. Is it correct? Law.
According to the land policy,
Oh.
yes.
For 3 years, the language is such allotment will stand cancelled if the land not utilized for the specific purpose within 3 years of allotment. That is of 1989. And my lord, the 1919 policy says, my lord, in case of transfer may be allowed within 50 years from the date of settlement. My lord, that is the provision is 15 years from the date of settlement with the approval of the government subject to the condition does not completely become landless. (1989) page.
What is a PIL? Is it
Yeah,
PIL?
it was a PIL, then my lord, then I marked that line, my lord.
The indigenous, local indigenous families. Local indigenous means what?
My lord, the indigenous villagers, the persons, because that was the land which was
Tribals.
Tribal, no?
All
But-
those peoples here.
But you are not a tribal, you are a.
it was my lord, I am the review petitioner. It was allotted to an industry, and he has sold that land to somebody else. That is why it was the PIL was. And PIL was dismissed on the ground that the provision of law was not been able to be placed before the honorable court.
That para number? Policy?
4.1, I have marked that line, my lord.
Such allotment will stand cancelled if the land is not utilized for the specific purpose within 3 years of allotment.
And my lord, in the PIL, your lordship, the order which I have before your lordship for review, at page your lordship has said that particular different.
So this and this land was initially allotted to whom?
Respondent number 5, JK Industries.
JK Industries.
And it was then within 3 years, it was allotted in 2002, and within 2005, he has sold those lands to somebody, third party, without utilizing it for the purpose which it was allotted.
Yes, what do you say?
Lordship, regarding the land, the lordship instruction needs to be placed,
No.
your lordship, so that whether it is ascertained the land is allotted.
Grazing
or
land.
not.
It
The
was a-
details of that particular property.
You want to take instruction?
yes.
Okay, let her take instruction. Okay. It has been submitted by Mr. P.K. Roy Chaudhary, Land Council, for the review petitioners that there is indeed a provision under para 4.1 of the land policy of 1989, which specifically bars that allotment of land will stand cancelled if the land is not utilized for the specific purpose within 3 years of allotment. Unfortunately, the said provision could not be produced, could not be brought to the notice of this court when this court passed the order on
Lordship
Page
on
17.
15/12/2021.
15/12/2021. Ms. Bordolo, on the other, however, submits that she may be given some time to take instruction as to the nature of the land which was being allotted, which will come within the purview of this para 4.1. So this matter come when?
Lordship, 3 weeks time.
3 weeks time.
It's a PI.
I can only smile because 3 weeks is a long period now.
Not adversary.
Huh?
It's not an adversary PIL.
Acha.
3 weeks back.
Okay, only September, 3 weeks.
Lordship, Lordship will be there until then.
That
There was a
was
rumor,
why-
your Lordship, that I beg your pardon.
I don't know any rumor. I have no idea what is we are totally, I have no idea that what the question you are asking also.
List of.
This,
And if you are.
May I please, your Lordship?
yes,
Lordship, I have prayer for listing of a case, my lord. In this case, my lord, the petitioner, my lord, he is appearing,
Monday,
my lord, on possible on Friday, my lord.
Monday.
My lord.
My please, my lordship, I'd like to mention for list.
Monday,
May I please, your lordship? I have filed my additional affidavit in item number 10. To be called. Keep your place.
Daily list for orders item 1.
what is this matter? Policy.
Waterlogging problem, lordships, Dibrugarh.
Oh, Dibrugarh.
Yes.
Oh, there was some, we thought there's some improvement. I don't know. We don't know.
Yes, instruction has been received.
Get a status report.
এখন দি দিব।
Can we have a?
They have a look, then we'll see what can be.
Lordships, it may be disposed of
Disposed
with liberty that in case the recommendations are not followed, we can approach the court, lordships.
Okay. The entire PIL, na?
Yes,
444.
Yes, yes, Lord.
Okay, likho. Han Mr. Han Ms.
S.
S.
Chakravarti.
Chakravarti, Lana Council for the petitioner, also Mr.
And that's my
and the Lana Council, Lana State Council. Na?
my lord.
The matter pertains to a very important issue. And the matter pertains to a very very important and a long pending issue affecting Dibrugarh township, whereby many major parts of the Dibrugarh town had been inundated and also inundated and water inundated with water logging in flooding, which has caused immense inconvenience to the public at large. The matter was moved in, this PL was filed in 2010. In 2010, and the pleadings would indicate that some steps appear to have been taken by the state government from time to time to deal with the situation. This certainly is an aspect of which the expertise, not only the initiative of the local bodies, but also would require the help of the experts. In fact, as per direction of this court, the government was directed to
The present status report.
to indicate the present status of the various measures undertaken to deal with this perennial problem of flooding and waterlogging in various parts of the Dibrugarh. In this regard, it has been submitted by the state government that
82% of
An
the
expert was, an
Sorry?
expert was appointed, lordships,
Give me some-
Professor A.K. Sharma,
in this regard that,
according to his recommendation.
okay,
82% has been completed.
sorry.
82% of the
Okay.
target is
An
completed.
expert was appointed in this regard, who had given some suggestions to improve to suggestions for improving the drainage system in Dibrugarh, which would ease the problem to a great extent. And in this regard, it has been submitted that on the basis of the such expert report, suggestion made, by one Professor
AK
A.K. Sharma IIT. The government has already undertaken works and
Do you want an extension that has been
Okay,
granted to the
okay.
contractor? This
okay.
is the name of the project.
Okay, and the project, namely improvement of drainage system of Dibrugarh town under NLCPR. Can you tell us the correct
Yes.
full name, full agreement,
Non-lapsable,
non-lapsable, NL
lapsable,
Central,
central, pool.
Project.
Project.
NLC, do you have the full form of this? NLCPR, Madam, Google, non-lapsable central pool of resources, under which 82% of the target of the funds and targeted have been completed, and it is likely to be it is likely to complete within
March
March 2024, which necessary extension of the work which being executed have been also given by the competent authority, and it is accordingly it has been submitted that the major work for improvement of this flooding in the Dibrugarh township will be taken care of. Full stop. It has been submitted Lanka Council for the state also submitted because of the aforesaid work undertaken. And the closing of the logging of water logging in major areas have been substantially reduced, and in fact there was no water logging recorded in the last 3 rainy seasons. In this regard, Lanka Council for the state also submitted a status report of the works already undertaken, under the aforesaid project of improvement of drainage system Dibrugarh town under NLCPR. Lanka Council for the petition also has expressed satisfaction in the improvement in the drainage system, reducing the water logging, and it is hoped that if the said project is fully implemented, perhaps the issue of water logging in major area of town can be addressed to a great extent, and some is that since there has been substantial improvement in the water logging problem because of the aforesaid implement of project, the PL perhaps may be closed. However, with the direction to the state authorities to complete the project as submitted by them, and also to take further necessary actions if which may be required from time to time, for which the petitioner also may approach the competent authorities, and also the court. With the above observation, a copy of the instructions so furnished before is also kept on record. With the above observation, PL stands closed. You write in the main PL. I close accordingly. Disposed of it. Then next.
Item number 2 for hearing.
What are you hearing, madam? You ready?
Your lordship, in this case, LCR may call for my lord.
Sorry,
LCR may call for.
what is this?
My
John
lord,
16 matter.
It was earlier dismissed for default lordship. Then it was restored lordship.
Oh, restored.
Yes,
lord.
that's in one.
Oh, okay. Let the LCR be called for.
My lord, in the meantime, earlier interim may continue, my lord.
In the meantime, the early interim will continue.
Lordship, allow her to have a copy, Lordship, copy of it.
Give a copy, furnish a copy.
My-
Item number 3,
May I please, your lordship? My lord, in this case, my lord, what happened, my lord? I have, my lord, I have submitted, my lord, all the, my lord, from 1966, my lord, and subsequent other voter list, my lord, of my parents, my lord. And my lord, my brother adduced evidence, my lord, in favor of me, my lord. And Gabora also adduced evidence, my lord. Even, my lord, I have been declared as foreigner, my lord.
But your evidence was discussed by the tribunal, your brother's evidence.
Yes, yes, my lord.
Then what did
My
the tribunal say?
What is the reason, my lord? I have been, my lord, declared foreigner, my lord. First reason, my lord, that the proceeding in her written statement stated in para 9 that her brother's name A. Latif Mia appeared in the voter list of 1907. But in her evidence as DW1, she does not state a single line. A. Latif is her brother. This is the one, my lord.
Para.
My lord, page, my lord, 55, para 5, my lord. This is the first line, my lord. Para 5, my lord, page 55. And second, my lord, during evidence, the proceeding does not disclose about the names and relation of the persons exhibit a
But
Akka
your brother Latif had appeared before the.
Yes, yes, my lord.
Where is his evidence?
My lord, his evidence, my lord, my brother evidence, my lord, page 48 to 50, my lord. Page 48 to 50, my lord.
It's not audible, Lord.
Gabor also
You
adduced,
can,
my lord.
yes, what to do, Mrs. Shamli?
Lordship, oral statement is not enough, Lordship. Only, otherwise, nothing, no documentary evidence he can able to place, Lordship, before the tribunal, Lordship. Otherwise, he totally failed to establish her. name,
Indian
Lordship.
Indian Evidence Act bars oral evidence or what?
Eh,
No, my lord.
eh,
Oral
and
evidence is no evidence as per
Eh,
Indian Evidence Act.
Yes, Lordship, this evidence. but
All these
Lordship,
other, all
in
these
case of
murder
foreigner-
charges, all will
in
be
case of
acquitted.
foreigners case, Lordship, in case of
PP is
foreigners
there,
case,
all the murder charges, all will be acquitted. We
Oh,
all are oral evidence.
no, Lordship. Oral evidence should be supported by documentary evidence, Lordship.
Even my lord,
And,
Gabor
that
also, my lord,
document-
adduced evidence, my lord.
Authenticity of that document should also be proved, Lordship.
Hmm.
And my lord, kindly turn to page, my lord, Gabura, my lord, evidence, my lord, page 52, my lord.
See the cross examination, this is the difficult.
My lord, cross examine.
Page 51,
Page 51,
and the learned tribunal ought to at least discuss
my lord.
that he has deposed this has been cross-examining, so for this reason, we are discarding his evidence. Kindly see. Page
Page
51,
51.
read it.
Prospered, Lordship.
Both. Yes, reaffirm. That's.
That OP Mazda Begum is my
That's
younger
it.
sister. She was born at.
It is your cross-examination. You kindly see the next part regarding shifting also reaffirm.
Any judgment in support of your plea? Any judgment?
My lord, this already, my lord, cross-examined, my lord. So this oral evidence is acceptable in my lord, in the, as per the, my lord, evidence, my lord.
Is it so?
Yes, ma'am.
Any judgment
Now, my lord, I have not available, my lord.
not available?
And Gabura also, my lord, reduced, my lord, in favor of me, my lord, with a certificate, my lord, that I am the daughter of my lord so and so. So and so, my lord. That is
That's-
page 52, my lord.
Certificate has been proved or
Yes.
what?
My lord, page 52, my lord.
Link,
Evidence, my lord, and 52 and Gabra certificate is also there, my lord. Gabra certificate, page, my lord, 33, my lord. Two Gaburas, my lord, issued certificate, my lord.
Gaumbra, where is it?
My lord, page 33, my lord. Paternal, from paternal side, my lord.
Gaumbra is DW?
The DW3, my lord.
DWC not discussed at all.
Yes, my lord, 52 page, my lord.
Where is Gaumbra's discussion, Mr. Sharma?
He also cross-examined, my lord.
Where is the discussion of DW2, 3, Gaumbra?
Gabura.
No.
No discussion, no?
No, my lord.
No discussion.
Okay, hard Mr.
As is Shikdar.
Counsel for the petitioner also hard Mr. Sharma लाने का सब नाम लिखो. In this petition, petitioner challenged the order dated, opinion dated 6/7/2018 passed with London Forest Tribunal 3 Borpeta in FT case number so and so page 54, by which the petitioner has been declared to be a foreigner of foreigner what?
Paragraph, Lordship,
2A, my lord.
it is discussed, Lordship. In regards of DW to Ikram Hussain, who issued the certificate as exhibit
Okay.
D.
And he's been declared foreigner of which very?
My lord, section only, my lord, section 2A of the Foreigners Act 1946.
Is 2A means
Two
what? 2A means what?
After my lord, 71, my lord.
Eh? 2A means 71. Who told you? Foreigners Act.
Yes. Foreigners means a person who is not a citizen of India.
If you go to Mr. Sharma, if you go to Delhi airport, you will find a lot of foreigners. Merely because a foreigner doesn't mean anything.
Yes, my lord.
Eh? He has to be declared illegal.
Illegal
foreigner.
migrants.
Otherwise, if you say you set up in foreigners terminal in Delhi airport, you have to send them all back. You have to declare them illegal. Unless they are illegal, you have to say that he has illegally entered India. That finding has to be there. That's what section 6A says. Every foreigner is not illegal. A foreigner may be, he may come before 1966, then what will happen? If he stays, he's an Indian, he will be deemed to be an Indian. See, Assam is a very peculiar state.
Yes, sir.
A foreigner may come, but if he comes after 1947, a foreigner, but before 1/1/1966. But if he stays and caste votes, he will be deemed to be Indian. 6A, what? Now,
Six.
and then again, the another
means-
category who may come in between 66 to 71,
Yes, Lord. They are getting.
even if he is declared a foreigner, he has a right to be registered.
Register.
Only those who come after 25/3,
1971.
97, then they are the real foreigners. They should be sent to detention camp, sent to Bangladesh. Only to Bangladesh. You can't send them to Pakistan or Myanmar or
Yes.
China.
Specified territory.
Only they have to send them to Bangladesh only. That also. Only one way. Only highway is Bangladesh. There is a peculiar law in Assam. So the foreigner tribunal has to say that he is a foreigner who had entered after 25/3/71. Then he will be liable to be
Reported.
deported. Then by this opinion, what the competent authority will do? He is a foreigner. Foreigner very well, but for which period? That is also important. I think we have to remand it. The tribunal has to give a specific finding when he entered.
When we come to paragraph 10. 55.
Mr. Sharma?
DW3. If you are doing DW3,
Hmm.
you will reach them. Only thing.
Not audible, Lord.
Yes, what do you want to say now? What to do with this order opinion? What do you say? Can it be sustained?
Lord. They
Huh?
remanded, but merit part will.
Shulman,
My lord, already my brother, my lord, governor reduced my lord, and
No,
since my lord
Gangura wanted
66, my
me.
lord. See,
What
my lord,
certificate he
all
had?
other subsequent voter list in my lord, all other subsequent voter list, my lord. My parents' name have been my lord incorporated, my lord.
and
From
you go,
66, my lord.
you go and tell convince this tribunal
What
member.
certificate?
Who is this tribunal member?
Even Lordship,
Huh?
certificate.
I think it's time for Judicial Academy to arrange training for these tribunal members. I don't know. Not because, judges, we are getting training, no? But they don't have any training, so they were not appointed as judges, they were perhaps lawyers initially, no? And many of them perhaps did not practice in lower court, we don't know. So that's the problem.
This is the certificate, Lordship, page 36, Lordship.
Mr. Sharma, kindly see, it as a general proposition. Page 55, come to page 55. Court discussed DW3 tribunal, but says there are vast contradiction in between the contents of certificate and deposition. That the evidence of DW3 is not corroborated and reliable. Now come to page 52.
Yes.
Reaffirm, everything reaffirm. You have cross-examination, he has reaffirmed. Where is the contradiction and not trustworthy?
Your brother is Indian,
Yes, my lord.
why is it?
My lord, is my lord 26, my lord.
He is 26.
Yes, my lord.
Yes.
What is your brother's name?
Abdul Latif Mia, my lord. Here, my lord. Latif
Khurshid.
Mia.
Tarabari.
Well.
And what is the opinion that your brother is Indian?
No.
What is the opinion?
My lord,
Mm.
here, my lord,
There are no
in order, my lord, it has been just, my lord, reflected that, my lord, I have stated in our written statement in 19 that his name has been listed in the voter list of
Who is this
1997. my lord.
Majida Begum?
Majida Begum is the proceeding, man.
Acha, Majida is the
Yes,
proceeding.
yes, ma'am.
Wife of Hakim Ali.
Yes, ma'am. And my parents' name, my lord, since 1966, my lord, in enlisted, my lord. In other, my lord, all other subsequent voter list. my lord.
This petitioner has challenged the opinion dated 6/7/2018 passed by Lana Forest Town 3 Spencer Biowas. The petitioner has been declared to be foreigner. We have heard the Lana counsel for the parties. Perusal of the impugned order dated 6/7/2018 indicates serious irregularities, deficiencies on the part of the learned tribunal in rendering the opinion. And accordingly, we have the view that the opinion can be sustained in law. For coming to this view, we have come to this view for the following reasons. Number one, though the learned tribunal stated that the proceeding in her written statement stated in para number 9 that her brother's name A. Latifa Mia appeared below voter list of 1977, but in her evidence, DW1 has not stated a single line that Latif is her brother. However, we have noted is that the said Abdul Latif had appeared before the tribunal and deposed himself as DW1, claiming
DW2, my lord.
DW2,
Right.
claiming that he is the elder brother of the proceedee. The evidence of DW, we have gone to the evidence of DW2, which appears in DW2, in which he was DW2, where he was examined by, he was also cross-examined, in which there has been clearly, in which he has clearly stated that he is the brother of the proceedee. That fact has not been, that the fact has been reiterated. There is nothing to show in the evidence of DW2 that his evidence is unreliable to the effect that he is the brother of the proceedee. Therefore, we of the view that the said finding of the learned tribunal is perverse and not based and contrary to the evidence on record. We also have noted that the Gaumbura had exhibited a document. The Gaumbura who had issued an order, which is a certificate.
Exhibit D.
Exhibit D. Where is Exhibit D? Page?
Page, my lord, 33, my lord.
That the proceedee is the daughter of Khurshid Ali, late Khurshid Ali of village Bandali Reserve, P.O. Jotradia, T.S. Tarabari, and she got married to one Hakim Ali. The said Gaumbura had duly appeared and reiterated and proved the certificate issued. No question was ever asked. No question was ever asked, doubting the genuineness of the certificate issued by the said Gaumbura. Though he was duly cross-examined, we have no reason why the said evidence of DW2 should have been ignored by the learned tribunal and held that the certificate was not proved.
Contradiction between contradiction.
Further, we have noted in para 10 of the opinion, the learned tribunal has held that there are vast contradictions in between the contents of certificate and the deposition of DW2. 3. And accordingly held that the evidence of DW3 is not corroborative and reliable. From what we have read from in the evidence of DW3, we do not find any contradiction. Rather, he supports the claim of the proceedee. On this ground also, we find that the finding of the learned tribunal is not in accordance with as per the evidence. There are many observations made by the tribunal, of which we do not wish to make any further observation. In as much as these observations are not in accordance with law, nor with evidence on record. We also have noted that learned tribunal gave a finding in para 14 that the petitioner is an illegal migrant oblique foreigner and declared the proceeding as a foreigner under Section 2 of the Foreigners Act 1946. We also fail to understand how this finding will be at all relevant for the purpose of dealing with such foreigners in the state of Assam. Law contemplates, as provided under Section 6A of the Foreigners Act, Citizenship Act, 6A of the Citizenship Act, as provided under Section 6A of the Citizens Act 1950, law contemplates that there are three categories of persons who may enter Assam from the specified territory of DDN Bangladesh, within bracket DDN East Pakistan. 6A as per 6A2 within bracket 2, as per 6A2 of the Citizenship Act 1955, all the persons of Indian origin who came before 1st day of January 1966 to Assam from the specified territory, including such those whose names were included in the electoral rolls used for the purpose of general elections to the House of People held in 1967, bracket close, and who have been ordinarily resident in Assam since the dates of the entry into Assam shall be deemed to be citizens of India is from the 1st day of January 1966. This is a very special provision provided to deal with such persons who may come from the specified territory, but they shall be deemed to be citizens. Thus, such persons, such foreigners also can be deemed to be citizens, as provided in Section 6A2, 6 capital A2. Further, there is another category of foreigners who are dealt with under 6A within bracket 3, under which such person of Indian origin who A came to Assam on or after 1st day of January 1966, but before 25th day of March 1971 from the specified territory, and B has, since the date of his entry into Assam, been ordinarily resident of Assam, and C has been detected to be a foreigner, such persons will be entitled to register himself with the competent authority, and such persons, after 10 years of such registration, can be treated to be Indian citizen,
Can apply for citizenship.
can apply for citizenship. Thus, even those foreigners, if they come within the aforesaid period of 1/1/66 and 25/3/1971 and found to be foreigner, can still claim to be Indian citizen, provided they register themselves with the competent authority. Though there is no reference to any other in the and under the Section 6, there is no reference to such other categories of foreigners who come after 25/3/1971, the obvious consequence is that since there is no such privilege or protection granted, they shall be treated under a normal law, under the Foreigners Act of 1946, and they would be accordingly dealt with. in terms of the aforesaid Foreign Essay 1946. Therefore, from the above, it is necessary for the Foreigners Tribunal to give a specific finding as to which category the petitioner belongs, which category of foreigners the petitioner belongs. Inasmuch as such finding will have a direct consequence on his or her citizenship. In the present case, there is no such finding, but a mere general observation that the petitioner is a foreigner, which in our opinion does not meet the requirement of law for the purpose for which the Foreigners Tribunal had been constituted. Under the circumstances, we are of the view that the order passed by the learned Foreigners Tribunal so cannot be sustained in law, and the matter is remanded for fresh reconsideration to give a fresh opinion on the basis of by taking into consideration the evidence which is on record. First up, accordingly, the petition is allowed by setting aside impugned so and so. The petition will appear for the learned Foreigners Tribunal within a period of 1 month from today, and hear the petitioner again, and the learned tribunal pass a fresh opinion in accordance with law as regards the citizenship of the petitioner. We need to mention उसके पहले तो we have gone through the records. Though we are prima facie satisfied that the petitioner appears to be appears to have produced all the relevant records, relevant documents, records to show that she is an Indian citizen, yet since it requires proper appreciation of all this evidence in record, which we have already held, the tribunal has not done, we direct the tribunal to reconsider the case of the petitioner in accordance with law.
Hello, my lord, kindly, my lord, it may 2 months, my lord.
Why 2 months? You are from where?
My lord, from my lord, Borpeta, my lord.
Borpeta. How far is Borpeta?
1.5 hours.
Huh? Borpeta and 2 months, why you want? If you say South Salmara or something, then Borpeta. 1 month, 1 month.
My lord. My lord.
Item number 4 and 5.
Any good news or
Good news, my lord.
good news? Oh, very good.
I've spoken to my kind man. He does not intend to
I
pursue
think
this
that's
matter any
very, I
further.
think very fair of him, I think.
Provided it has already been promoted, although my lord, is promoted under the career advancement scheme, not the cadre promotion, but without going into these technicalities, my lord, we don't intend to pursue it.
I
any
think that
further.
is a very, because what we saw, because there is only 19 also, we can still hear now, with the 2010, you know, see now how many years, more than a decade
I
has passed.
appreciate it.
So
I
I think
appreciate.
that's a very fair, I think, because, and also you are in a profession which are very different, no?
My lord.
Contenders, you know,
Exactly.
you are not in some, and they will keep on fighting all throughout their life. You are a professor, you know, more enlightened
My-
category. So we are very happy with the news which you have conveyed to us. Yes, Mr. Chakravarti.
My lord, when he is not pressing, only thing in the appeal, my promotion was interfered with, lordship will protect that.
Obviously, of course. That goes without saying. Yes, anything you want to say?
It is with me.
Okay. Yes, Mr. We will record your statement. We are not relying on any private statement. Your authority. Your okay. When this matter was taken up, it has been submitted by Mr. Gogoi, the Standing Counsel for the Education Department, Higher Education Department,
Technical department.
Technical Department, Higher Education Technical Department, that though You are Mr.
I'm Dr. Bipul
Bipul,
Talukdar.
huh? Okay.
I'm for joint.
Though, yes, though the principal respondent, Dr. Bipul Talukdar had challenged the promotion of Dr. Jayanto Pathak during the pendency of, during the litigation period. The principal respondent, Bipul Talukdar, has been already promoted to the post of professor in the year
Recently, my lord. So,
recently.
please. With effect from
Having recently promoted with effect from
2012.
2012.
3/3/2012.
3/3/2012. The Jayanto Pathak was also recommended for promotion by order dated 11/11/2021. Though challenged
21.
2011.
2011.
Though by order dated 11/11/2011. Though challenge and it was confirmed by the government of Assam, was recommended for promotion to the post of professor by order dated 11/1/2021. Though was subsequently
By the recommendation by the selection committee on 21/7/2010.
anyway was subsequently confirmed by the government of Assam by order dated 29/2/2012. With effect from what?
Yes, from the date of joining.
Oh, that is from the date of joining, that is
11/1/2011.
11/1/2011.
And that was.
And
subsequently
though
confirmed by
that
APSC.
was subject matter of challenge, because of interim order passed by this court, he has continued to remain professor uninterruptedly. And thus we find that the aforesaid factual position has not been disputed by any of the parties. Thus, what we find is that both the contesting parties have been serving as professors with effect from 2011 and 2012 respectively. More than a decade has elapsed, though the certain issues has cropped up as to the legality of the recommendation made by the selection committee by the principal respondent, Dr. Bipul Talukdar. Considering the fact that they have been serving as professors for more than a decade, Mr. Bipul Talukdar has fairly submitted that he does not wish to pursue this matter. This court, in view of this court, appreciates the stand taken by Dr. Bipul Talukdar, which will lead to culmination, closure of this proceeding, which has been going on for a long period. As a consequence, since the Dr. Bipul Talukdar has opted not to pursue the challenge to the promotion of promotion of Dr. Jayanto Talukdar Pathak, his appointment as a professor also will stand affirmed. Will affirm. Accordingly, in view of the above submission made, the present writ appeal is closed. Close. Anything else you want to add?
My lord.
In 5, that is our appeal, man. We are not pressing it.
Okay, cool, sir.
On instruction, man.
Yes.
Okay. Okay. In view of this order is passed, this in this we pass in number 4, no?
Yes.
Then number 5, the in view of the first of number 5 in item number 5, in view of the order passed today in WA number 13/2/2000, whereby Mr. Bipul Talukdar has decided not to press the petition, the present appeal also stands closed as not pressed. In the result, the interim the impugn order passed under a single judge. Single judge has set aside.
The
recommendation of the selection. We in the result in item number 4. In the result, we set aside the impugn order passed by the learned single judge in
WPC
of 4672.
in order dated
order dated
dated
my lord
26,
26/11/2010.
11/2018 in WPC number 4672 of 2010 to then by affirming the selection made selection and subsequent order passed by the government appointing Dr. Jayanto Pathak as a professor. However, the legal issues which have been raised in this petition being not decided on merit is kept open to be to be decided as and when necessary.
Much obliged. Highly obliged.
Item number 6.
Thank you, Council.
What?
So in this case,
Huh?
my lord, the petitioner, my lord, went for working as mason at my lord Jorhat from Dhubri district, lordship. My lord, reference was against him, lordship. My lord, kindly see page
So what is wrong with the
65, lord.
what is wrong with the opinion?
Page 65 kindly been seen, lordship. My lord, the learned tribunal, my lord, has opined. My lord, my lord, the finding is that his father was very much present in my lord 67, my lord, in this soil. But the petitioner has been declared, my
If
lord.
your
within
father
this
is in Nihon, then he won't go to Bangladesh to produce him. Then only he
65
can become a
correct of mine.
Bangladeshi. Eh? Yeah, Mr. Sharma. Huh?
As per this tribunal order, he has already registered his name, my lord.
He registered
And
because
he
of
is now
to avoid
claiming
arrest.
citizenship
lordship.
under section 3(1)(a), lordship, 3. And this is a general provision, lordship. And
How old are you? When did you register yourself?
My lord, 1981, my lord.
When did you register yourself?
1981, I was born, lordship.
Oh,
Well,
when did you
registered-
register yourself?
Yes, registered because I was.
When did you register yourself?
My lord,
Which date?
after passing this order,
Oh, when the order was passed?
my lord, it was passed, lordship.
Hmm.
That is 30/10/2018, lordship. My lord, registration, my lord, that is the last page, page 67, lordship. It was done, my lord, on 30/11/2018, lordship. My lord, because of my lord, to avoid arrest, lordship,
persons who are getting benefit under section 3(6)(a).
You also a manufacturer. You also manufacturing company.
no,
Huh?
lordship.
The tribunal says you also manufacture documents.
No, lordship.
You are a private manufacturing
No,
company, private limited. You manufacture
I am just my lord,
documents.
constructor of house, lordship, mason.
Hmm? Your house mason, you
Yeah.
manufacture house and also documents.
Illiterate person, lordship. The birth certificate, my lord, it was a
Illiterate person.
lordship.
Lordship, my humble submission is that, lordship,
And findings
Allow
can
me-
be seen, lordship.
No, but what is it that your father is in? Then why is it? Where is it?
My lord, father is he.
There are five.
He reduced evidence, lordship.
Father
Paragraph
say had
five.
valid present. See, in
Paragraph
view of
five,
the
page
finding in
65.
para 5, I don't think it will be contradictory, Mr. Sharma. You can't say the father is Indian,
Yes,
but the son is
No.
foreigner.
but I am declared as foreigner, my lord, in this team. lordship.
Because what is the implication? That means he went to some foreign country to give birth to him. Then he came thereafter.
Lordship.
Lord.
Huh?
Just a minute, Lord.
Mr. Sharma, what is this? Para 5, you see,
My lord,
cell you see.
ma-
So
marriage,
he
lordship.
belongs to the earlier stream, no? Where
Yes,
falls
Yes,
within
Lordship.
67.
Lordship, 67 documents. 66 to 71 stream. Lordship.
So he went to Bangladesh during this period.
No, he is getting the benefit of registration, Lordship, already.
Correct, but then you have declared his father to be an Indian, no? To show that father had valid presence over soil in this country. So
Country
he came here, then he again went back
in
to Bangladesh.
1967, Lordship.
Huh?
In 1967, Lordship.
No, I was born in
No, prior
1981.
to 1966, Lordship.
So his father is involved in it.
Prior to 1966, Lordship, he could not able to place any document, Lordship. And Lordship, already he's getting the benefit of this order, Lordship.
Mr. What do you are protected also, register also, close it.
That is because that does not mean my right of citizenship is curtailed, lordship. Because of my lord, I was apprehended by the police, my lord, for avoiding arrest,
He
my
is
lord. I
accepting this
arrested
order,
myself,
lordship.
lordship. I challenge that order, lordship.
You are at 220 matter. How it was fixed today? There are so many people who are waiting for their turn.
It was listed the day before yesterday, lordship.
Why?
It was fixed today, lordship. My learned friend, my lord, was dateless on that day, lordship. Because of that, it was fixed, lordship.
20, you are already registered. Only thing that you can't vote, that's all. Isn't it?
Yes, lordship. Now,
No.
it has curtailed his right, lordship.
What curtail is right? What is
Citizenship
the
law.
other right which have been curtailed apart from voting?
No.
My lord, right
No,
of
that's not
citizenship,
right.
lordship, this is a valuable right, lordship. Section, my lord,
These are FT hearings.
FT hearing in easy, Rehna Bibi. They are 2016, they are waiting since 2016. You are at 20 and you are also in registered, nobody put.
I arrested because of lordship. My lord, section 3A, lordship. Of the Citizenship Act, it says,
Okay, you are already protected. You want to hear, you will fix another date. The hearing, see, all matters are pending.
Monday,
We
lordship.
can, huh? No, not Monday.
No, lordship.
Okay. After Bihu, February. As per list after Bihu, as per chronology.
Lordship, February, Lordship,
Huh?
after Bihu.
After Bihu, as per chronology. Next. Review.
Item
Hanufa
7.
Khatun. Hanufa Khatun. What is this Hanufa
Oh my
Khatun? What is this matter, Mr. Collitor?
Lordship, Lordship recollects there is a delay issue is there.
How much
And
delay?
we wanted to address your lordship whether in the review petition is there is any time bound frame has been laid down by any statute or whether a limitation act will be applicable. Whether the High Court rules will be applicable. So in this connection, lordship, I was supposed to argue or like submit in this matter, and I am ready with the matter, lordship, because under delay part only, because
Okay.
the proposition is that lordship, with though in the writ petitions, the limitation act is not applicable, whether in the review petition, the limitation act will be applicable or not, and if it is not applicable, then whether there is a time frame or like benchmark has been laid down by any statute or by any proposition of law by this honorable court or Supreme Court of India. So this is what I wanted to place before law.
Review application, there is no condonation, there cannot be any condonation.
No, I'll try to convince your lordship that there is though limitation act is directly not applicable to the review applications in the writ jurisdiction, but there are various case laws wherein it has been stated that delay analysis is already there in the writ petition and in the review also it is there. But what will be the time frame? So in many cases, what has been stated by this honorable various high courts is that analogy will have to draw from the Limitation Act. If Limitation Act says that the review is in the civil suit in 30 days, then in writ also the basic benchmark has to be taken as 30 days. And if it is beyond 30 days, then of course there will be a discretionary jurisdiction on the High Court. But still, that benchmark has to be 30 days, and the beyond 30 days, that has to be properly explained. So those are the case laws that I have got. So also I would like to place
So
those.
now you concede that limitation act per se directly is not applicable so far relating to review of a power exercise under Article 220.
So I directly do not concede because, lordship, I wanted to place certain rules because High Court rules stated in some places, because though there is no direct provision stating that review has to be filed within 30 days or 60 days or whatever. But like High Court rule says about the appeal, 30 days High Court, 30 days appeal time period has been given by the High Court rules. High Court rule is a special law under the Guwahati High Court Act. So Assam High Court Act.
But read court's review power comes from where?
The
Where's
writ
source
court's
of
review power comes from the plenary jurisdiction of the
Then-
High Court to a constitution that is.
It's a court of record.
It's a court of record,
It's
it's
a court
correct.
of record. It can correct its own records at any time. That is the power of
Now,
review.
now that,
But delay and lessons
that-
might be
that-
applicable.
now that is what lordship, like, what will be the time frame? What will be the
That will
time
depend
period?
upon what is the reasonable.
What,
whether-
yes, lordship,
that-
that's what, the reasonable
That's why
time.
my question is
Yes.
whether limitation act per se is directly applicable.
No, as far as the the proposition of law has been settled by by various courts, it says that directly the limitation act is not.
That is what I was asking.
Directly not.
Not
But like only thing is that lordship, what I want to stress on, that like what will be the benchmark? Because-
That is applicable in case of writ petition also.
The
Forget about
delay
treaty.
in lectures is there, lordship, but what will be the benchmark? Benchmark will be 30 days from limitation act or not? That is the issue here. Because in many of the cases, Gujarat High Court, Mumbai High Court, as well as Guwahati High Court, your division bench have stated that 30 days benchmark has to be taken from the limitation act. Though it is not directly applicable. And that has been borrowed from the judgment from the Supreme Court. We say that like that in the writ petition also, that delay part has to be looked into and it cannot be filed at any point of time. The cause of action has to arise and it has to be taken a step from this. So that issue lordship has to settle.
How many days delay, Mr. Singh,
My lord, here this
in
case, my
filing
lord,
the review petition?
the petitioner has approached the Supreme Court, my lord, and the matter has been remanded back by the Supreme Court. That order was passed on 6/12/2019.
Then you filed the review petition when?
My lord, we file on 2021, my lord.
So what I lordship, I
Yes.
suggest lordship, because there is a confusion going on, because there is one one judgment from this honorable High Court on a single bench judgment, Kanak Chandra Sharma, which says the limitation act is not applicable, so delay of continuation petition is not required. That is perfectly fine. But look, whether this benchmark 30 days is required or not, that has to be seen. If lordship settles that, then this all confusion will
No,
go.
there cannot be any benchmark.
So
See, when
That also-
you put a benchmark discretionary power of the High Court, you are reducing the High Court to a CPC code.
lordship, I'll have to place this.
So
case
it
in
all will
lordship.
depend the facts of the case. Maybe
No,
even a
no,
delay
no,
of 10 days may be fatal in some cases.
Yes, lordship. We are.
You don't know, but
No,
even
that is
10
correct.
years also, Supreme Court also has condoned 10 years delay also.
Yeah, I agree with that, but it's.
And we have condoned many appeals filed by the state government also was 3 years also.
No, lordship, as far as review is concerned, Supreme Court is also very strict. Supreme Court 30 days only. In Supreme Court also 30 days, review power is only 30 days limited.
But 226 even it's far more
In Supreme
than
Court,
even 32.
correct, lordship, that is correct, but what I am submitting before your lordship is that.
Mr. Kolita, we do not want to limit this power and we cannot, 226.
But lordship.
Don't limit the power of the Article 226 just because you are dealing with foreigners tribunal.
No, not
It
226.
will have a repercussion.
No, lordship, I'm not.
Don't emasculate the power of the High Court.
That is, but
You will pay the price later on. Then at appropriate case, we will find that yes, because the law laid down in relating to arising out of foreigners tribunal can also apply in other proceeding.
lordship, not because of foreigners case,
It is
in
what-
all the cases, lordship.
Because we have been
lordship,
condoning delays about 3-4 years also.
lordship, these cases are not relating to foreigners cases. These cases are from different cases, but all the cases are under 226. And those cases I want to place the lordship. Our High Court has stated, lordship, that 30 days benchmark should be taken into account. I'll place before you, lordship. This is a case by Justice Ansari and Mr. Hari from our High Court only. It has been specifically stated. Then there is a case from Gujarat High Court, there's a case from Mumbai High Court. All these cases, lordship, it's stated that benchmark of 30 days has to be taken from the limitation act only because it provides 30 days.
Any case laws from Supreme Court?
Supreme Court,
benchmark?
Supreme Court, because all these cases, lordship, these high courts, they have borrowed this idea from the Supreme Court case, one Supreme Court case that I'll place before your lordship. So basically from this, all these laws have has come out from this case only. Lordship may kindly see page paragraph 21, 20 and 21.
These are all taxation laws. Taxation laws
No,
are.
Lordship, that's the principle of law, because this case has been followed in other cases that I'm going to place it for. your lordship.
Taxation law, see, we are dealing with fundamental rights. These are 1964. 1964, we have marched how many, almost more than a decade.
But this is the case.
How
law
many?
that has-
About 50 years.
This is the
We
case.
have
law that
marched
has been followed
50
here.
years more. Now we are standing different. And see, they are dealing with fundamental rights. These are all statutory rights.
I'll leave it to you, Lordship. If your
No,
lordship
no,
have
you know, it's
different
not question
views.
of living, but see, let us also rely on, because these are all laws which have been evolved to deal with statutory laws
But this is the law
about
which has
delay,
been by
civil court.
these other high courts. So I'll just read out that particular paragraph, because it has taken the idea from that that limitation period which has been prescribed under the Limitation Act. Paragraph 21, if your lordship may read it, your lordship.
What will be the limitation for this kind of fundamental rights?
Now,
Because
lordship,
this relation was to consider a recovery of money.
I understand. your
Taxation statute, recovery
understand.
of money,
I
it
understand.
was 3 years.
I understand.
But what will be the, in a comparable level, what will be the limitation in a comparative set of so far relating to fundamental rights?
So-
What with whom, which we will compare?
No, that I understand that is from a statute of income tax.
So we can
and
say
there's a
this
recovery.
perhaps may not be applicable in the facts of the case.
Lordship, so this case has been followed.
We
in
can say
other
this,
three-
perhaps we can say
cases.
that this judgment which are rendered in the context of a recovery of a commercial transaction, perhaps may not be applicable in a case dealing with fundamental rights of a citizen.
Yes, Lordship, that I'll leave it to your Lordship. There are other three cases, Lordship. I'll
What are
just
the other
place-
three cases? Then we'll,
I'll place this Guwahati High Court. Guwahati High Court case here, Lordship.
why the Guwahati High Court case? They are also from foreigners, tribunal.
No, these are not from foreigners, sir.
Anything from foreigners, tribunal?
No, foreigners, nothing.
Because that's why there is sui generis. There
Foreigners
is
tribunal
no,
not taking-
there is no
because of-
comparable law in other high court. We don't
So
see.
this case, Lordship, has dated this case-
Limitation Act, applying review pass on
This
226
is
High
under
Court.
226, 226 review.
High Court would not ordinarily entertain an application for review if the same is made beyond 6 years as prescribed, and the High Court said has sufficient for not employ. Okay, we also, yes, the sooner the better, of course. But
So Lordship, I'll just read out this case, because this case has discussed this Kanak Chandra Sharma's case also, a single bench judgment, which says that in the review petition, a Limitation Act is not applicable. It was thoroughly discussed, and later on, and it has been laid down in paragraph 9, your Lordship. May I read at least paragraph 9, your Lordship?
Mr. Sikdar, how long will take?
Well, 20 minutes,
20 minutes.
20 minutes.
Yes, Ghosh also, Ali also, the M Ali, also you are going to appear. Ali, 20, yes, how much you are going to take, Mr. Ali?
5 minutes.
5 minutes, 25. Miss Ghosh? Huh?
10 minutes.
10 minutes. 35 minutes. And Mr.
I'll take some
Kolita?
time, I'll take some time.
How long?
I'll take some, at least 45 minutes. Lordship.
45
I'll have
minutes.
to go through all this.
I mean, at least today, difficult, I don't know, whether some matters also.
After the Bihu, anytime if your lordship wishes.
Which is the other judgment you are referring to?
These are the, these are from, this is from the Guwahati High Court. Then there are from other high courts, your lordship. May I place before your lordship? I have the copies of these judgments. Okay. There's one from the Gujarat High Court and one from Mumbai High Court. Yes. Bombay High. These are all division bench judgments.
No. So if we go by this Mori Riba, generally be 30 days, we accept it. It would be, however, remain open to the High Court to entertain in a given case an application for review, even if an application is filed beyond 30 days. So that is it, we need not discuss on law.
One.
Then now we'll come to the facts.
No, one more judgment, the Gujarat High Court, Lordship, one paragraph, I'll just read it out. One paragraph, Lordship.
Yes.
Paragraph 9. Then Ahmedabad Electricity Company case here, Lordship. Then I have given a copy
Lakshmi
there.
Sambas Khande.
No, not that one, that is Mumbai High Court, the Gujarat High Court, another one.
Okay,
There is Ahmedabad Electricity Company here, Lordship.
yes,
I'll just read one paragraph, Lordship.
yes,
Paragraph 9.
yes.
We are conscious that this court, while considering the application seeking review of an order passed under Article 226 of the Constitution of India, has plenary power, and in exercise of plenary power, High Court exercise the discretion. It is true that there is no limitation provided for filing an application for review of an order passed under Article 226 of the Constitution. However, as observed in an unmistakable terms in the case of MP versus Vailal Bhai, there is a Supreme Court case, Lordship, I have referred to, by the bench comprising 5 judges of the Honorable Supreme Court, that though provisions of Limitation Act do not as such apply to granting relief under 226 of the Constitution, same principle in our opinion would apply in case of application seeking review of the order under Article 226 of the Constitution. As pointed out earlier, in the said judgment of the Supreme Court has observed that, however, the maximum period fixed by the legislature as the time within which relief by suit in civil court must be brought may ordinarily be taken to be a reasonable standard by which the delay in seeking remedy under 226 can be measured. In the instant case, as pointed out earlier, Article 226 to the 26 of the schedule to the Limitation Act prescribed is 30 days for filing review. So that is, they have referred to the Limitation Act. Limitation Act says under 124 that is 30 days for review. So 30 days for filing review application on the same analogy of principle laid down in the case of State of MP versus Vailal Bhai, the maximum period fixed by the legislature as the time within which the relief for a review application must be paid may be ordinarily taken to be reasonable standard by which delay in seeking remedy of review can be measured. In the instant case, the period of limitation under 124 of schedule to the Limitation Act is 30 days. So they have referred to the Limitation Act again. However, the application seeking review has been filed after a delay of 500 days, which is much more. So the measure that they have taken is, Lordship, they have
We also
taken
keep,
the
we also
analogy
keep
from the
here also
limitation.
measure. We will also keep 30 days here also. No
30 days.
problem.
So
We also-
that proposition, Lordship, if
No
Lordship
problem.
agrees to Lordship.
No
then-
problem,
then-
but then we'll depend on the fact of
No,
the
the
case.
facts are that I don't have any
No
issue.
problem.
So ratio is Limitation Act is not applicable.
Limitation Act is not applicable, but analysis
What I could understand, Limitation Act is not
per se
applicable.
is not applicable.
Not applicable.
But analysis has to be drawn from there while filing a suit. If it is 30 days, then in the writ also.
And
we'll have
in
to
the
say-
Constitution bench, the Honorable Apex Court has said, even it can be dismissed if it's less than the period
Correct,
prescribed.
correct,
Then
correct. That's correct. That's correct. That Lordship has the discussion. I'm not disputing that.
our discussion is to exercise properly,
Yes,
judiciously.
yes, that is
So
there.
that judgment, you go to the next line, it says, even if less than.
Less than also, not that I
then-
agree. No, I have
So
read it.
therefore, Limitation
No,
Act is having
I
no role.
have read it, your Lordship. I agree to that. But the benchmark should be 30 days, and after
Para-
30 days benchmark, if in the facts of the case, 1 day delay also can be fatal also.
Para
Today's delay will be
21,
considered.
Middleton, learned counsel is right
Yes.
in his submission that the provisions of limitation do not as such apply to granting relief under 226.
Yes.
So this is, it appears to, however, maximum period within must be brought ordinarily be taken into reasonable standard. We'll take it also.
So that is,
problem.
but my
We'll take it
submission
ordinarily,
is
they
that.
should
Lordship,
come
I'm
at earliest. But if they don't come, what do? Do we dismiss? The Supreme Court does not say, you should dismiss also.
That discretionary power, Lordship will be always
that-
having it.
that-
I don't dispute that.
One there is
But
there.
only thing is that, Lordship.
So will of course depend on whether they have been snoring away or
Yes,
what.
yes,
We'll see that, what kind
that
of,
is what Lordship has to say. Lordship has
what the,
to say.
what the.
But Lordship may kindly point out.
So what is the fact of the case?
So facts, Lordship, I'm not.
Here, my lord,
This is the judgment you want to rely?
All these judgments I wanted to refer to.
Yes,
So as per the facts are concerned, Lordship, it
yes,
will take.
yes, what is the fact of the case?
the
No,
petitioner's father is Bhutari in 19.
no. That the delay
Delay, my lord, the judgment of the tribunal is 2017.
No, delay in the seeking review.
My lord,
Have you explained?
my lord, we have approached the Supreme Court, my lord. And the Supreme Court has.
Hanifa Khatun.
Yes, my lord. My lord, at page 73. That case was closed with a liberty to approach this on court in review. My lord. Delay होने की explanation है क्या?
So when this court dismissed on 6/12/2019, you filed a review petition.
My lord,
That is what we are concerned.
my lord,
When did you file this review petition?
my lord, we have filed on
In December, it was closed with liberty. Then when did you file the review petition?
we have filed in
16
14/9/2020.
And that you have to explain why did you take so much of time? That you have to explain.
There is no explanation in the petition.
There is no explanation. Then you have to explain. You have to explain for condoning delay, you have to explain. No, you can't just, there has to be whether that explanation is sufficient. Is there is another for a court to decide, but you have to give an
My
explanation.
lord, in fact, my lord, in petition, we have not made any statement.
Then you file an additional affidavit, sorry, then we can't pick it up. That oral statement,
No, there is no explanation. also.
that unless you give a explanation for the delay, we cannot consider. But
Well,
that is a
we-
basic
we-
principle also, that we must be satisfied that the reasons given are reasonable. That you have to file. You may file, yes. List is matter after vacation. In the meantime, the petitioner may file additional affidavit. Yes, next. Surya also. Have you explained?
18/9.
Huh? Have you explained the
There
delay?
is no delay.
Huh? 89 is not delay. Then what is delay?
Read petition.
Just a minute, then there is another review petition, that's Ghosh. Just a minute. Ghosh, have you there explained delay? Huh?
As much as I can, it's well explained.
And this 8/9 key, what is this Surya Bhanu? For hearing,
My lord, simple issue, my lord.
what simple issue?
The Albios
The
report,
reviews
my lord, devoid of, my lord, Albios report, my lord, devoid of any materials, my lord. My lord, this court has already rendered so many judgments. My lord, the Albios report.
But why it is listed today, 21 matter? See, there is a list, they will complain against
Fixed
us.
matter, my lord.
Huh?
Earlier it was fixed.
Why it was fixed? No, he says that hard Mr. So-and-so, since the request is released the matter for an along with after ensuing vacation, the no Tariq was fixed. He should have come along with his bench.
My lord, simple
date
issue,
was
my lord,
fixed.
this may decide, my lord, only the Albios report, my lord. It doesn't say that she is an illegal migrant, my lord. And it was my primary challenge before the tribunal also. Case 27.
Anyway, this will hear, we will let it to hear. Because see, there is no date fixed for hearing today. Yes, next. Next.
Item number 10.
Review, yes, Ghosh, have you explained the delay?
Yes, Lordship.
What is the delay?
There is delay.
Lordship,
Lordship.
they have filed an additional affidavit today itself. here.
Yes,
And it
it's
was
there
not
in the
explained, it
record
was
and
not
we have,
explained earlier.
we have served a copy also to them and it's. there in the
But
record.
you can't expect the council to read your brief today in the court hour. They have to given time.
But delay, I have explained also in the main review petition. as
Where is
well.
that?
It's paragraph 11, Lordship, financial constraint.
Because the financial constraint
then-
cannot be a ground of
And then
filing a petition in a delayed.
in my additional affidavit, I was in the detention camp pursuant to the impugn order. And I was released on 28/12/2019 from the camp. 28/12, that means in the month of December. Thereafter, I applied for the certified copies and all, I obtained the documents. And subsequently, I had filed the review petition in the year 2022, Lordship. And in the second affidavit which I have filed, I have clearly mentioned, Lordship, why there was delay.
So he was in detention.
Lordship, from the detention also, Lordship, I mean, they have their family members. And I mean, like people are from the jail also, people are filing cases. It's not that
Yes, jail.
it cannot be done. I mean, that cannot be a ground of this thing.
That was the-
But I
A
have
person like
stated
when
also,
a
I
person
don't
is-
have.
Lordship, when a
finances.
person is declared foreigner,
When you were detained,
he'll
Yes.
be detained, he'll be inside the jail only.
Yes, pursuant to the order, immediately he was arrested.
when there is
So he'll be
judgment is,
arrested only.
Impugned judgment. ये मेरा notebook में दो. Tribunal order is at
Yeah,
page
it was
52.
Sarah का तो मैं बोला, it's 52. Nothing to do.
29/4/2016.
29,
4/2016,
so he has been detained and released when,
release in the year 2019, 28,
28?
28/12/2019, he was released. From the camp, this writ petition was filed. So
Ah.
the affidavit was shown by the cousin. They didn't take interest because he is from the marginalized section.
No, this review petition, when did you file a review
A
petition?
review petition I had filed in the year
This review, this,
22.
huh?
Review was filed
No,
on
when the,
9/2/22.
why did you file the review petition? Because your petition was dismissed.
Yes,
Earlier,
Lord.
huh?
Yes.
And that dismissal was when? When was the dismissal?
Dismissal was on 11/5/2017.
So after 5 years,
Dismissed.
Yes, Lordship.
Where is the order?
Order is at page
91 year.
90, Lordship.
It will be like big thing and release people to the heavy care.
But why, on what ground you are seeking review of this order?
Because I got the documents
Which
later on.
document? What kind of
Voters
document?
list of 1981. And that was one of the 89th Lordship. That was one of the ground while the impugned order was passed. That I did not submit any voters list of mine prior to 1997. So 89 voters list now I have 94 voters list and subsequent all the voters list. He has submitted only 5 documents, 66, 70.
But that was not the only ground.
With due diligence, he could not take out.
No, but that was not the only ground on which it was rejected.
No,
You were
Lordship.
dismissed. The other grounds also given,
Yes, Lordship.
extract volume, so and so.
And the ground of the impugned order, Lordship, that voters list of 1966, there was overwriting by the learned tribunal that
Lordship, one. Lordship, as far as Lordship, the voter list is concerned, Lordship, whether this can be a ground for review. because these voter lists are public records. And these records are readily available before any of the public, before the public authority, and those could have been procured. And now they did not use.
See, but there are other
proper
grounds
data.
also on which ground you were
On this
rejected.
The Gaon Panchayat Secretary Lordship,
Huh.
he has stated, he has done the inquiry that I am the resident of, may I read his evidence, Lordship? Gaon Panchayat Secretary's page
So
43.
it's like reopening the whole case. All these things have been already argued.
My lord, this is an important, citizenship right is an important right. Even
Everybody knows
the,
citizenship is
so-
a
Sonwal
important right.
Sarvananda
For illegal
Sonwal said-
immigrants, citizenship is no, they doesn't bear anything. Citizenship right is right for the citizens, not for illegal immigrants.
Genuine citizen should be thrown out.
You come legally with proper visa, passport, nobody will say anything.
First employer, I think.
When did you receive the affidavit, Mr.
Today only. Lord
Today I
Secretary.
tried, Lordship, yes.
Today only.
Huh?
What? We haven't received it.
No, we have served a copy in
Office,
office has
office,
received.
office. They are still lying in the office.
We don't have an office only, like, it's running from our chambers.
No, at least they should go through.
Quite an extra copy.
No,
also.
that is okay, but you can't insist that you must read now and understand now. You can't insist that you must read it now and understand it also. They may also like to have some view on that. They may like to,
Lordship may take it up some other time with my learned friends.
if you had filed
Convenience.
earlier, then now if you have filed it, it has been submitted at it is submitted by Mr. Kolita. No, it has been submitted by D. Ghosh, Line Counsel for the petitioner. She has filed a additional affidavit. Today.
Yes, Lordship.
Today. Mr. Kolita submitted he is, even if it is filed today, he is not in, he has not been brought to his notice. And equally seeks for some time to examine the same. This is the matter again, at
Monday, Lordship, if it's possible, or on Tuesday.
After the new vacation.
after Monday, after
Tuesday, Lordship.
vacation.
Tuesday is a hearing day.
17 also hearing day, Tuesday,
17 will be difficult.
after, okay then.
17th, Lordship.
Or 19,
17.
19 again, 19,
Lordship, either on
19,
18th, because
19.
19th, I'll be out. Lordship.
19.
18th, if it's possible on 18th.
19,
19.
19.
18th I had-
Don't go by rumor of Bordoloi.
No, I'm not on that, Lordship.
Item number 11.
Deeply obliged.
Yes, review,
Yes, my lord.
same, delay.
From Supreme Court.
I think we have to
Page
hear
9, my
together.
lord, paragraph 8. my lord.
Because see, we have to pass the orders distinguishes what Mr. Kolita has, he has
Yes.
done a lot of hard work also.
Yes.
To
Lordship may
to-
kindly consider.
no, certainly, that is what. We will not just ignore this. These
Yeah,
are important.
Because that benchmark thing, Lordship, I believe.
Correct. So we have to make our observation also, even
Lord-
if we don't agree with that, we have to
Absolutely,
give reasons.
absolutely.
That is the reason.
Lordship.
Yes, case number.
On 19th. Thank you. Please stop.